the issues before us. And now, Heavenly Father, we offer the same prayer as offered by President John Adams in November of the year 1800. When praying over the President's house, he uttered the following prayer, then had it etched into the mantle of the house. I pray heaven to bestow the best of blessings on this house, all that inhabit it and shall inhabit hereafter. May none but the honest and wise ever rule under its roof. Heavenly Father, we ask these things in the name of your Son, Jesus Christ. Amen.
Amen. Now be led in the Pledge of Allegiance by our page, Kyra Perrin. Kyra.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Senate will advance third order business, reading corrections to journal.
March 12, 2013, the Judiciary and Rules Committee reports that the Senate Journal of the proceedings of March 11, 2013 was read and approved as corrected. Lodge Chairman.
Report will be filed in the office of Secretary. Senator Work will be recorded present at this order of business. Senator Davis.
President, personal privilege, if I may.
You may, Senator.
Thank you, Mr. President. Senators, a quick roadmap. It is our intent to work our way through the various orders of business. The only matter that we currently have in the 10th order of business is not intended to be picked up until Friday, so we will be staying out of the 10th order of business. In short, we'll work our way as quickly as we can to the 13th order of business and begin the legislation there and in the order that the bills appear on your calendar. Mr. President, I ask unanimous consent in advance to the 6th order of business.
Without objection, Senate advances 6th order of business. Prior to advancing, Senator Bayer will be recorded present at this order of business. Senate's at the 6th order of business.
March 12, 2013, the Judiciary and Rules Committee reports that Senate Bill 1158 has been correctly printed. Lodge Chairman.
Senate Bill 1158 will be referred to the Commerce and Human Resources Committee.
March 11, 2013, the Judiciary and Rules Committee reports that the Senate amendments to Senate Bill 1114, 1133, 1138, 1106, and House Bill 142 have been correctly printed. Lodge Chairman.
The report will be filed in the office of Secretary. Senator Bayer will be recorded present at this order of business.
March 11, 2013, the Judiciary and Rules Committee reports that Senate Bill 1114 is amended, Senate Bill 1133 is amended, Senate Bill 1138 is amended, and Senate Bill 1106 as amended have been correctly engrossed. Lodge Chairman.
Senate Bills 1114 is amended, 1133 is amended, 1138 is amended, and 1106 is amended. Refer to the 11th order of business, first reading.
March 11, 2013, the State Affairs Committee reports it has had under consideration the gubernatorial appointment of Sheila A. Olson to the Idaho Commission on Human Rights, term to expire July 1, 2014. The committee recommends that said appointment be confirmed by the Senate. McKenzie, Chairman.
Senator Stanton will be recorded present at this order of business. The report of the State Affairs Committee will be referred to the 10th order of business and held for one legislative day.
March 11, 2013, the State Affairs Committee reports out House Bill 73 with the recommendation that it be referred to the 14th order of business for amendment. McKenzie, Chairman.
House Bill 73, without objection, will be referred to the 14th order of business for amendment.
March 11, 2013, the State Affairs Committee reports out House Bill 53 and House Bill 159 and recommend that they do pass. McKenzie, Chairman.
House Bills 53 and 159 will refer to the 12th order of business.
March 11, 2013, the Finance Committee reports out Senate Bill 1152, 1153, and Senate Bill 1154 and recommend that they do pass. Cameron, Chairman.
Senate Bills 1152, 1153, and 1154 will refer to the 12th order of business. Second reading.
March 11, 2013, the Judiciary and Rules Committee reports out House Bill 105 and recommend that it do pass. Lodge, Chairman.
House Bill 105 will refer to the 12th order of business. Second reading.
March 11, 2013, the Resources and Environment Committee reports out House Joint Memorial 1 and recommend that it do pass. Pierce, Chairman.
House Joint Memorial Number 1 will be referred to the 10th order of business and held for one legislative day.
There is no further business in the sixth order, Mr. President.
Senator Davis.
Mr. President, I ask unanimous consent to advance to the 8th order of business.
Objection, send advance the 8th order of business. Messages from the governor sent us at the 8th order of business.
March 11, 2013, the Honorable Brad Little, President of the Senate. Dear Mr. President, I have the honor to inform you that Tom Stroshan of Moscow, Idaho, was appointed to the State Board of Health and Welfare to serve a term commencing January 7, 2013 and expiring January 7, 2017. This appointment was made subject to confirmation by the Senate and notice of appointment is hereby given. As always, Idaho, C.L. Butch Otter, Governor of Idaho.
Appointment of Tom Stroshine will be referred to the Health and Welfare Committee.
There is no further business in the eighth order, Mr. President.
Senate will advance the 9th order of business. Messages from the House sent us at the 9th order of business.
March 11, 2013. Mr. President, I transmit herewith House Bill 219, 252, 254, 242, 176, House Bill 90 is amended, House Bill 193 is amended, House Bill 171 is amended, House Bill 120 is amended, House Bills 262, 263, 243, 202, 222, and House Concurrent Resolution 20, which have passed the House. Alexander, Chief Clerk.
House Bills 219, 252, 254, 242, 176. House Bill 90 is amended. House Bill 193 is amended. House Bill 171 is amended. House Bill 120 is amended. House Bill 262, House Bill 263, 243, 202, 222, and House Concurrent Resolution 20 will all be referred to the 11th order of business for introduction.
March 11, 2013. Mr. President, I transmit herewith enrolled House Concurrent Resolution 7 for the signature of the President. Alexander, Chief Clerk.
The President has signed House Concurrent Resolution Number 7, and it will be returned to the House.
March 11, 2013. Mr. President, I return herewith Senate Bill 1031, 1101, 1102, 1103, 1104, 1001, 1003 as amended, 1004, and Senate Bill 1027, which have been signed by the Speaker. Alexander, Chief Clerk.
Senate Bills 1031, 1101, 1102, 1103, 1104, 1001, 1003 is amended, 1004, and 1027 will be for the Judiciary and Rules Committee for transmittal to the Governor.
There is no further business in the ninth order, Mr. President.
Mr. President, I ask unanimous consent to advance to the 11th order of business.
Objection, Senate advance the 11th order of business. Introduction, first reading of bills. Senator Davis. Senator Cameron will be recorded present at this order of business. Senator Davis.
To Senate Good East, call the chair.
Objection, Senator Beatties.
Mr. President.
Senator Hagedorn.
Thank you, Mr. President. While we're at ease, Senators, I would like to introduce some folks from my district, the Eagle High School government class, taught by my old seatmate, Mark Snodgrass. Thank you for coming. Help me welcome them.
Senate will come to order. Senate's at the 11th order of business. Senator Davis.
Mr. President, I ask unanimous consent that all bills on first reading be read by number, author, and title only, and the journal show they've been read at length.
Objection so ordered.
In the Senate, Senate Bill number 1159 by State Affairs Committee, an act relating to solid waste disposal, to establish provisions relating to compliance with notice and meeting provisions in certain circumstances relating to instances where a board or county or commissioners or city council is considering adopting any alteration, addition, expansion, or other modification in the design or operation of a solid waste disposal site. In the Senate, Senate Bill number 1160 by Finance Committee, an act appropriating monies to the State Liquor Division for fiscal year 2014. In the Senate, Senate Bill number 1161 by Finance Committee, an act appropriating monies to the Department of Self-Governing Agencies for regulatory boards for fiscal year 2014. In the Senate, Senate Bill number 1162 by Finance Committee, an act appropriating monies to the State Controller for fiscal year 2014. In the Senate, Senate Bill number 1163 by Finance Committee, an act appropriating monies to the Commission on Hispanic Affairs for fiscal year 2014. In the Senate, Senate Bill number 1164 by Finance Committee, an act reducing the appropriation to the Division of Vocational Rehabilitation for fiscal year 2013. In the Senate, Senate Bill number 1165 by Judiciary and Rules Committee, an act relating to attorney's fees, to revise a provision relating to attorney's fees when an insurer fails to pay a person entitled.
Senate Bills 1159, 1160, 1161, 1162, 1163, 1164, and 1165 will all be referred to the Judiciary and Rules Committee for printing.
In the Senate, Senate Bill number 1114 as amended by Judiciary and Rules Committee, an act relating to behavioral health services, relating to the declaration of policy. In the Senate, Senate Bill number 1133 as amended by Judiciary and Rules Committee, an act relating to school security plans, to establish provisions for school security plans and to provide that certain plans and reports are confidential and exempt from disclosure. In the Senate, Senate Bill number 1138 as amended by State Affairs Committee, an act relating to the Local Planning Act, to provide that overlay zoning districts have specific standards. In the Senate, Senate Bill number 1106 as amended by State Affairs Committee, an act relating to health savings accounts, to provide for health savings accounts for state employees who choose a high deductible health plan.
Senate Bill 1114 is amended, Senate Bill 1133 is amended, Senate Bill 1138 is amended, Senate Bill 1106 is amended, will all be referred to the 12th order of business, second reading.
In the House of Representatives, House Bill number 142 as amended in the Senate by Health and Welfare Committee, an act relating to dentists, to revise provisions relating to a dentist who practices or represents himself as practicing dentistry under any other name than his own true name or under a business name.
Senator Durst to be recorded present at this order of business. House Bill 142 is amended in the Senate will refer to the 12th order of business, second reading.
In the House of Representatives, House Bill number 219 by State Affairs Committee, an act relating to firearms, to provide certain prohibited acts regarding firearms by public employees and officers of governmental entities. In the House of Representatives, House Bill number 252 by Appropriations Committee, an act appropriating monies to the Department of Insurance for fiscal year 2014. In the House of Representatives, House Bill number 254 by Appropriations Committee, an act appropriating monies to the Department of Environmental Quality for fiscal year 2014. In the House of Representatives, House Bill number 242 by Revenue and Taxation Committee, an act relating to property taxation, to revise provisions relating to site improvements as business inventory exempt from property taxation. In the House of Representatives, House Bill number 176 by State Affairs Committee, an act relating to absentee voting, to define a term and to provide voting requirements for overseas electors. In the House of Representatives, House Bill number 90 as amended by Judiciary Rules and Administration Committee, an act relating to the retail sale of liquor by the drink, to clarify the transferability and non-transferability of certain liquor licenses. In the House of Representatives, House Bill number 193 as amended by State Affairs Committee, an act relating to prepaid wireless telecommunication service emergency communication fees. In the House of Representatives, House Bill number 171 as amended by Transportation and Defense Committee, an act relating to highways, to provide that county or highway district has actual notice of an encroachment that is unsafe for pedestrians or motorists. In the House of Representatives, House Bill number 120 as amended by State Affairs Committee, an act relating to the Idaho State Lottery, to revise the powers and duties of the Idaho State Lottery Commission relating to the methods to be utilized in selling lottery tickets and shares. In the House of Representatives, House Bill number 262 by Appropriations Committee, an act appropriating additional monies to the Office of the State Appellate Public Defender for fiscal year 2013. In the House of Representatives, House Bill number 263 by Appropriations Committee, an act appropriating monies to the Attorney General for fiscal year 2014. In the House of Representatives, House Bill number 243 by Revenue and Taxation Committee, an act relating to sales taxation, to provide that application software accessed over the internet or through wireless media is not tangible personal property. In the House of Representatives, House Bill number 202 by State Affairs Committee, an act relating to the Idaho Administrative Procedure Act, to provide additional requirements relating to the public notice of proposed rulemaking. In the House of Representatives, House Bill number 222 by State Affairs Committee, an act relating to veterans, providing a short title and legislative intent. In the House of Representatives, House Concurrent Resolution number 20 by State Affairs Committee, a concurrent resolution stating findings of the legislature and rejecting a certain final rule of the State Athletic Commission relating to rules of the State Athletic Commission.
House Bill 219 will refer to the State Affairs Committee. House Bills 252 and 254 will be referred to the Finance Committee. House Bill 242 will be referred to the Local Government Committee. House Bill 176, House Bill 90 as amended, and House Bill 193 as amended will all be referred to the State Affairs Committee. House Bill 171 as amended will be referred to the Transportation Committee. House Bill 120 as amended will be referred to the State Affairs Committee. House Bills 262 and 263 will be referred to the Finance Committee. House Bill 243 will be referred to the Local Government and Taxation Committee. House Bills 202, 222, and House Concurrent Resolution 20 will all be referred to the State Affairs Committee.
There is no further business in the 11th order, Mr. President.
We'll advance 12th order of business. Senate's at the 12th order of business. Senator Davis.
Mr. President, I ask unanimous consent that all bills on second reading be read by number and author only, and the journal shall have been read at length.
No objection, so ordered.
In the House of Representatives, House Bill number 55 by State Affairs Committee. In the House of Representatives, House Bill number 251 by Appropriations Committee. In the House of Representatives, House Bill number 253 by Appropriations Committee. In the House of Representatives, House Bill number 255 by Appropriations Committee.
House Bills 55, 251, 253, and 255 will all be referred to the 13th order of business, third reading calendar.
There is no further business in the 12th order, Mr. President.
Senate advance 13th order of business. Senate's at the 13th order of business. Has for final consideration Senate Bill 1079. The Secretary will read the bill.
In the Senate, Senate Bill number 1079 by State Affairs Committee, an act relating to Internet crimes against children, to provide additional duties of the Attorney General and to make technical corrections, to create the Internet...
Mr. President.
Senator McKenzie.
Mr. President, I ask unanimous consent that we dispense with further reading of Senate Bill 1079, but our journal shall be read at the third time at length, section by section, and that it's now before the Senate for final consideration.
Hearing no objection, Senator McKenzie is recognized to open debate.
Thank you, Mr. President. Senators, this relates to something called the Idaho Internet Crimes Against Children Task Force. It's something that had been implemented 5 years ago and housed in the Attorney General's office. It is an office that investigates Internet crimes involving children, child enticement and pornography mostly, but also trading in human persons as well. It's been funded by grants in the past, and they've used part-time positions from local law enforcement agencies to handle this. I know Boise City has at least one investigator who is an expert in this area of the law and has served on this. But with the combined resources that they've had 2 to 3, basically equivalent of 2 to 3 full-time positions for the entire state of Idaho. To give you a context of what they can do, a trained investigator who is doing it full-time can investigate 25 to 30 cases in a year. We get over 5,000 leads of these types of cases every year in this, and Paul Jagosh, who's the Fraternal Order of Police lobbyist, started describing to me some of the things that they investigate, and I just asked him I didn't even want to know some of this stuff, but it's all things that are detrimental to children, and it's not just viewing things online. They've found out that about 80% of those who view this stuff have actual live victims, and nationwide, the average offender has over 22 victims before they get caught. And so these investigations proactively stop children from sexual abuse. There's no doubt about that. And it prevents a cycle, too, because as those kids who are abused grow up, there's a cycle of abuse, and it just goes on until it gets stopped. And so what this bill would do would make that Internet Crimes Against Children Task Force a permanent division or section or unit within the Attorney General's office. What it does not do, though, it does not appropriate any funds for that, either general funds or for dedicated funds. That would have to be a separate decision from the finance committees and then come to the floor. And there's a couple of possibilities, and if you look at the fiscal note, it describes what the proposal that the speaker from the body across the way had come up with, but potentially, if we authorize this bucket to capture some funds, we do have something called the Consumer Protection Fund within the Attorney General's office, which is kind of collects whenever we have settlements against defendants in these nationwide lawsuits. If someone's defrauding Idaho citizens, we join in a lawsuit or sue them separately through the Attorney General, and he gets a settlement. It goes into the Consumer Protection Fund. And so what the proposal would be, if we set up this bucket to create the task force, is potentially see if we want to separately authorize the funds to come from that unit in order to fund this. And the costs that we would looked at would be a pretty big hit. It would be $2 million in the first year. That is basically equipment, but about 1.6 of that is personnel. That's one deputy AG, a legal secretary, a couple forensics examiners, and then 9 to 10 criminal investigators who actually follow up on these leads. And so it's something that there's a need in Idaho to protect these kids. You know, I think this is, in one way, an expansion of government to create this, but it also hits directly at the most basic function of what the government does, which is public safety, and public safety of our most vulnerable citizens involving children. So I think it's a good thing. We have a proposal that if we do this, that we can fund it not through the general fund, but through the Consumer Protection Fund, where we collect more than we collect usually millions every year. It just depends, but pretty consistently we collect the funds for that. And so I think it's a good policy, and I think it is good for the state of Idaho. And with that, I'll open debate. And I know if you have questions that I can't answer, I've got Fraternal Order Police on the line that they can help if you have questions that I can't help you with. With that, Mr. President, debate is open.
Further debate? Hearing no further debate, Senator Winder.
Thank you, Mr. President. I just rise in support of this and commend the chairman for his efforts. We've all been working on this for a couple of sessions now. I really want to thank the Joint Committee for their efforts in finding this fund without having to go through the general fund and hurt other areas of state government. And I think this is a high priority for our state. If there's anything we can do to protect our kids, I think we need to. I think this is an effort to do that. Thank you, Mr. President.
Further debate? Hearing no further debate, Senator McKenzie is recognized to close debate.
Thank you, and I should have mentioned that there's several members of this body, the senator from 20, senator from 10 also, and the chairman of our Judiciary and Rules Committee has also had input on this, as well as several members of the body across the way. And the other thing I should have added before is that these investigations still have to comply with the Fourth Amendment, which is protection against warrantless searches and seizures, and as well as statutes relating to this. It doesn't give them any authority to conduct internet searches beyond what's already permitted under the Constitution and statutes, but just allows them to follow up on leads that we couldn't follow up on before. Thank you. With that, debate is closed.
Debate being closed. The question is, shall Senate Bill 1179 pass? Senate Secretary will call the roll.
Bear. Bayer. Bach. Brackett. Buckner-Webb. Cameron. Davis. Durst. Fulcher. Getty. Guthrie. Hagedorn. Hyder. Hill. Johnson. Keogh. Lacey. Lakey. Lodge. Martin. McKenzie. Mortimer? Nonini? Nuxel? Patrick? Pierce? Rice? Schmidt? Sidaway? Stennett? Thane? Tippett? Fick? Work? Winder? Bach? Davis? Guthrie?
Roll call shows 35 ayes, no nays, no absent excused, majority having voted affirmative. Senate Bill 1079 is passed. Senate, the correction title. Hearing none, titles approved. Senate Bill 1079 will be transmitted to the House. Senate now is for final consideration. Senate Bill 1059 is amended. The Secretary will read the bill.
In the Senate, Senate Bill number 1059, as amended by Judiciary and Rules Committee, an act relating to the control of venereal diseases, to revise provisions relating to the examination for and treatment of certain diseases of persons confined or imprisoned in any state prison facility in Idaho.
Mr. President.
Senator Mortimer.
Mr. President, I would ask unanimous consent that further reading of Senate Bill 1059 as amended be dispensed with, and the Journal show it has been read the third time at length, section by section, and placed before the Senate for final consideration.
Hearing no objection, Senator Mortimer is recognized to open debate.
Thank you, Mr. President. Senators, the purpose of this minor modification to Idaho Code Section 39604 is to update the venereal disease examination and testing process of Idaho's incarcerated population. These modifications are based on medical best practice. They also make sense fiscally. Currently, the Department of Correction examines all inmates for venereal diseases upon prison entry and excuse me, the word just got me. They conduct these tests often, how about that, for HIV and RPR, which is syphilis for all the other offenders. At this time, Idaho Code Section 39604 requires that all offenders are tested for HIV upon release, with the current practice allowing any offender to receive HIV testing upon request or opt-in testing. The modification proposed is for Idaho Code 39604 to reflect the opt-in testing option. This would allow an offender the choice to receive testing for HIV or other venereal disease prior to release from incarceration. This bill further clarifies that the state is not obligated to treat or be financially responsible once a person is released from incarceration. Mr. President, debate is open.
Further debate? Hearing no further debate, Senator Mortimer is recognized to close debate.
Thank you, Mr. President. I confess my sins and recognize that routinely caught me. Thank you. Debate is closed.
Debate being closed. Question is Senate Bill 1079 is amended. Passed. Senate. Senator Winder.
Thank you, Mr. President. I ask unanimous consent the roll call vote used for the passage of Senate Bill 1079 now be used for the passage of Senate Bill 1059 as amended.
Hearing no objection, roll call shows 35 ayes, no nays, no absent excused, majority having voted affirmative. Senate Bill 1059 is amended. Passed. Senate. The correction title. Hearing none. Titles approved. Senate Bill 1059 be transmitted to the House. Senate now is final consideration. Senate Bill 1018 as amended. The Secretary will read the bill.
In the Senate, Senate Bill number 1018, as amended by Judiciary and Rules Committee, an act relating to jury selection and service, to provide a correct code reference and to revise provisions relating to contempt proceedings for a prospective juror.
Mr. President.
Senator Lakey.
Thank you, Mr. President. I ask unanimous consent that Senate Bill 1018, as amended, be further reading be dispensed with, and that the Journal show that it's been read the third time at length, section by section, and placed before the Senate for final
Hearing no
consideration.
objection, Senator Lakey is recognized to open debate.
Thank you, Mr. President. And good senators, this initially started as a fairly simple, straightforward correction of defects and omissions in the law coming from our good Supreme Court. The bill does correct an incorrect code subsection reference in Idaho Code 2-208, and there are conflicting code sections that deal with the contempt sanctions for those that do not appear for jury duty. The older code section 2-208 provided for a $300 maximum penalty and 3 days in jail. The idea was to bring that code section in line with the current code section under Title VII, Chapter 6, the more recent code section, and also provide the additional protections that come with the current Supreme Court rules. The primary challenge that we ran into was that the new code section provided a maximum penalty of $5,000 for those that do not appear for jury duty and are held in contempt. And as we discussed that, we felt that was a little bit steep, jumping from $300 to potentially $5,000. After a fair bit of discussion and effort to reach consensus, the current bill would increase that $300 maximum penalty to $500 maximum penalty for contempt for not appearing for jury duty. And with that, Mr. President, I would open debate.
Debate being open, is there further debate on Senate Bill 1018 as amended as amended? Hearing no further debate, Senator Lakey, Senator Keogh, excuse me.
Excuse me. Thank you, Mr. President. Would the senator from 12 yield to a question?
Senator Lakey, would you yield?
Certainly, Mr. President.
Keogh for the inquiry.
Thank you, Mr. President. And Senator, the language that's being struck on lines 29 and 30 speaks to a juror or potential juror showing good cause for his failure to appear. And I'm wondering if similar language exists someplace else, and I'm just not finding it here.
Senator Lakey.
Mr. President, Senator from 1, thank you. Good question. The new subsection, or the new language, does refer to the Idaho Supreme Court rules, which do address the due process procedures there. There is a process where the individual isn't simply held in contempt. They have to receive a summons from the court to display due cause and explain their absence from not appearing for jury duty. So there is due process provided. They do have an opportunity to explain before the court holds them in contempt.
Thank you, Senator, and thank you, Mr. President.
Further debate? Hearing no further debate, Senator Lakey is recognized. Closed debate.
Thank you, Mr. President. Debate is closed.
Debate being closed. Question is, so Senate Bill 1018 is amended passed Senate. Senator Winder.
Thank you, Mr. President. I ask unanimous consent the roll call vote used for the passage of Senate Bill 1079 be now used for the passage of Senate Bill 1018 as amended
Hearing no objection, roll call shows 35 ayes, no nays, no abstentions, excused, majority haven't voted in the affirmative. Senate Bill 1018 is amended passed Senate. The correction title, hearing none, title is approved. Senate Bill 1018 is amended, will be transmitted to the House, Senate, and House for final consideration. Senate Bill 1045 is amended. The Secretary will read the bill.
In the Senate, Senate Bill number 1045 as amended by Transportation Committee, an act relating to veterans, to revise the definition of veteran and to provide a definition of active duty.
Mr. President.
Senator Hagedorn.
Thank you, Mr. President. I ask unanimous consent that further reading of Senate Bill 1045 be dispensed with and a journal show it's been read the third time at length, section by section, and placed before the Senate for final consideration.
Hearing no objection, Senator Hagedorn is recognized to open debate.
Thank you, Mr. President. Ladies and gentlemen, Senate Bill 1045 is overdue. Currently, the state has a definition for veterans for hiring practices only. That's what this is defining. And that particular definition is very old. In fact, some of it had been repealed as far back as April 10th of 1989. And so we needed to update this veterans definition. We currently have about a 10% unemployment rate for veterans as compared to non-veterans, it being about 7%. So we've got a gap there that we need to help our veterans through state hiring practices that this will help resolve. The change is consistent. If you will look on lines 41 through 47, the change is consistent with that as defined in U.S. code, except we've got it kind of slimmed down and in our code. This veterans change has been supported by, or the definition has been supported by the American Legion, the VFW, the Disabled American Veterans, and a Marine Corps League, and a lot of smaller veterans organizations as well. We tried to do this for the last couple of years, but we kept running into roadblocks of various kinds. We think we've got the correct language this time. So with that, Mr. President, debate is open.
Further debate? Hearing no further debate, Senator Hagedorn is recognized. Closed debate.
Thank you, Mr. President. Debate is closed.
Debate being closed. Question is, so Senate Bill 1045 is amended passed Senate. Senator Winder.
Ask unanimous consent the roll call vote used for the passage of Senate Bill 1079 be now used for the passage of Senate Bill 1045 as amended.
Hearing no objection, roll call shows 35 ayes, no nays, no absence, excused, majority haven't voted in the affirmative. Senate Bill 1045 is amended, passed Senate. The correction title. Hearing none, title is approved. Senate Bill 1045 is amended, will be transmitted to the House. Senate now has for final consideration Senate Bill 1105. The Secretary will read the bill.
In the Senate, Senate Bill number 1105 by State Affairs Committee, an act relating to the Legislative Department.
Mr. President.
Senator Lodge.
Thank you, Mr. President. I ask unanimous consent that further reading of Senate Bill 1105 be dispensed with, and the Journal show it has been read for the third time at length, section by section, and placed before the Senate for final consideration.
Hearing no objection, Senator Lodge is recognized to open debate.
Thank you, Mr. President. Good Senators, this legislation is before us at the request of the Legislative Council, which recommended this change in the audit process for the legislative branch to save money, to increase efficiency, and to address a small separation of powers issue. And we always like to hear that, save money and increase efficiency. This bill makes two changes in the audit process for the legislative branch. First, it would change the audit cycle from an annual audit cycle to a 2-year biennial audit. And the second change is to move the oversight of the audit from the Board of Examiners to an executive branch entity to the Legislative Council. Currently, every year the Board of Examiners selects a CPA firm to audit the legislative branch, which includes the Senate, the House, LSO, and OPE. The cost is about $15,000 every year and also requires a great deal of indirect staff resources from the Senate, the House, physical staff, as well as 2 to 3 LSO auditors who are pulled off existing assignments to assist. There has not been an audit finding of any consequence in 20 years for the legislative branch, which is a pretty simple financial structure consisting of just personnel costs and operating support costs for the most part. We don't have multiple programs or federal pass-through dollars or complicated third-party contracts. Having an audit done every other year and tying it to a 2-year legislative term would save money and not tie up the time, the legislative staff time every year. The Council estimates that we could probably save about 1/3 of the cost by moving to a biennial audit. Each year would still be audited with no loss of transparency, but the actual audit would take place every other year. Most executive branch agencies are audited on a 3-year cycle, so the legislative branch would still be held to a higher standard. The judicial branch has oversight of its audit process, so moving the oversight of the legislature's audit process under the Legislative Council is both appropriate and consistent with the separation of powers issues. And with that explanation, Mr. President, debate is open.
For the debate, Senator Hill.
Thank you, Mr. President. Under Rule 39H, I'd like to disclose a potential conflict of interest. As
we'll have 35 of them, Senator, but go ahead.
Well, but as the pro tem, I both initiate and approve many of the transactions that come under this particular audit, and so I want that to be disclosed.
It will be so recorded in the Journal. Further debate? Hearing no further debate, Senator Lodge recognized closed debate.
Thank you, Mr. President. Debate is closed.
Debate being closed. Question is, so Senate Bill 1105 passed the Senate. Senator Winder.
Thank you, Mr. President. I'd ask unanimous consent the roll call vote used for the passage of Senate Bill 1079 be now used for the passage of Senate Bill 1105.
Hearing no objection, roll call shows 35 ayes, no nays, no absence, excused, majority haven't voted affirmative. Senate Bill 1105 passed Senate. Other correction of the title. Hearing none, the title is approved. Senate Bill 1105 will be transmitted to the House. Senate now is for final consideration. Senate Bill 1112. Secretary will read the bill.
In the Senate, Senate Bill number 1112 by State Affairs Committee, an act relating to proceedings before the Public Utilities Commission to revise the Public Utilities Commission's authority regarding schedule, rate, fare, toll, rental, charge, classification, contract.
Mr. President.
Senator McKenzie.
President, I ask unanimous consent that we dispense with further reading of the bill but our journals show we read it the third time at length, section by section, and that it's now before the Senate for final consideration.
Hearing no objections, Senator McKenzie is recognized to open debate.
Thank you, Mr. President. Senators, this bill addresses the two sections of code that set the policy, the procedure, the timing for rate cases for when our investor-owned utilities go before the Public Utilities Commission to change their rates. If they change them up, if they set time of day restrictions or different rates for that, or they're increasing rates, they have to go before the Public Utilities Commission in a rate case. And the timing and the procedure for that are set in two sections of code, 61-622 and 61-623. The problem with those two code sections is that on their face, they contradict each other. And Mr. President, if I could refer to our Idaho Supreme Court, its opinion, Mountain View Rural Telephone Company versus Interstate Telephone Company, 1935 case. It's at 55 Idaho 514.
Having thoroughly identified the source, the Senator may read.
And so the Idaho Supreme Court looked at these two sections. They said, quote, upon their face, they are in conflict with each other, inconsistent and contradictory, period and end quote. In another case, they said, in order for us to actually interpret 61-623, we have to assume that the legislator meant to put the word not in there where it does not actually appear. And so over the 100 years that we've had this code section, the PUC has just basically tried to apply it not as it was written, but in a way that actually makes sense. And I would also note that back when they passed this, which was actually 100 years ago, they weren't very fond of punctuation as we are today. And if you look in your code books at 61-623, which is the section that we're deleting and putting into 622, the first sentence of that is 228 words long. And so that's not a good way to write guidelines. And so what we did is 4 or 5 years ago, I believe the then pro tem had asked the Public Utility Commission to draft language that reflects what their current practice is, and had that language. It never went anywhere. And then this session, I and the co-chair of the interim committee brought that language back and sent it over to the Public Utility Commission chairman and asked him, we've got language. We want to make sure that this reflects your current practice, doesn't change any of the procedures or time frames. We sent it to the Public Utility Commission, to the investor-owned utilities, and then ratepayer groups. I think the food producers have a subcommittee on this, and then some of the larger ratepayers ratepayers or energy users were involved and reviewed the language. We got some comments back from one of the investor-owned utilities, and we sent that back to the PUC. They looked at that, and we incorporated that language into the bill that you've got before you. So what you see has been reviewed by the PUC, their staff, the investor-owned utilities, and the ratepayers, and all of them agreed that what it does is reflect the current practice, takes out that contradictory and inconsistent language, and just provides clarity to what the process is right now. And so really, that's all it does. I think it's good policy to clear up bad language when we can, and I don't know of any opposition to this. With that, Mr. President, debate is open.
Maybe no further debate. Senator Sidaway.
Mr. President, I had a concern about this bill on the second page on sentence 6, where it reads, prior to the expiration of said periods of suspension, the Commission may, with the consent in writing signed by the party filing, new tariff or schedule. And, when I read that, it looked like the Commission is over these utilities that come before them, and and if there's a rate case settled, or if there's a toll or a charge or whatever put on that utility that they are given initially, I think it was 30 days to react to that, and if they didn't, then they had an additional 5 months before that was implemented, and if that didn't work, then they had another 60 days to implement it. And then, if I'm reading this sentence properly, then they can, if they get that utility's permission that they're supposed to be regulating, if they get that utility's permission, then they can suspend that rate or suspend that fee or suspend that toll or that charge indefinitely. You know, and I had a great story about a chicken that didn't turn out as good as the chicken as the last time I told a story about a chicken. And I thought with all these young people up here in the balcony that maybe I ought to tell this story because it had a nexus to this bill, but I'm not going to do it. I'm not. I've saved you all from that chicken story. But I do have a concern that this maybe puts the fox in charge of the hen house. But I'm going to vote for this bill.
Further debate? Hearing no further debate, Senator McKenzie is recognized to close debate.
Thank you. I'm disappointed we don't get to hear the story, but yeah, that provision which to extend the rate case out, there has to be consent of the party filing. That's the current practice, and I actually talked with the commissioner about that, and he said, well, if the commission needs additional time to look at the rate case, the utilities is going to consent to that, because if they don't, it's just going to be a denial. And so if the commission needs more time, they can do that. But it's just his current practice. You know, there wasn't an intent to change anything in here, either in favor of the utilities or the ratepayers, just to reflect what the practice is and get rid of some bad language. Mr. President, with that, debate's closed.
Debate being closed. Question is to Senate Bill 1112 pass the Senate. Senator Winder.
Thank you, Mr. President. I ask unanimous consent the roll call vote used for the passage of Senate Bill 1079 be now used for the passage of Senate Bill 1112.
Hearing no objection. Roll call shows 35 ayes, no nays, no abstentions, excused. Majority haven't voted in the affirmative. Senate Bill 1112 passed. Senate, the correction title. Hearing none, title is approved. Senate Bill 1112 will be transmitted to the House, Senate, and House for final consideration. House Bill 130 is amended in the Senate. The Secretary will read the bill.
In the House of Representatives, House Bill Number 130, as amended in the Senate by Resources and Conservation Committee, an act relating to irrigation districts, to revise irrigation district
Mr.
election.
President.
Senator Tippett.
Mr. President, I ask unanimous consent that further reading of House Bill 130 as amended in the Senate be dispensed with, and the journal show it's been read at length, third time, section by section, and placed before the Senate for final
Hearing no
consideration.
objection, Senator Tippett is recognized to open debate.
Thank you, Mr. President. Senators, this legislation helps ensure that elected irrigation district board members meet the statutory requirements for holding office, and this is more important maybe in this case than in some other positions because one of the requirements for being a member of an irrigation district board is that you own property within the irrigation district. And there have been some problems with this in the past, at least in one occasion. And the land ownership is a requirement for voting and holding office in an irrigation district, and that requirement has been upheld by the U.S. Supreme Court and is current state law. So this doesn't deal with that requirement, only with certifying that the board member meets that requirement. So under this legislation, candidates are required that they meet the statutory requirements both at the time that they file for the office and at the time they're being sworn in. Candidates are also required to affirm that candidates also have an ongoing, duty to report any change in their qualifications, and districts are prohibited from including candidates on the ballot who are not qualified. So it's just a process to make sure they're qualified at the time they submit their name to be considered for a board member position. If that changes during the period of time that they're running for office, they are required to report that, and they have to also certify at the time they're sworn in. Currently, in Idaho Code, it's a misdemeanor to hold an office for which you're not qualified. So this legislation will prevent that from happening again. As a result of the amendments that were made at the 14th order the other day, the bill also provides for the election of an irrigation district director on the date of the next general election of the irrigation district, when the person who is elected in the previous election is not qualified to serve in that position. Previously, the language would have required someone to fill out the remainder of that term without having an election. This legislation will improve the integrity of the election process by ensuring that irrigation district directors are qualified to hold office, and it's a good clarification to the law, and senators were not aware of any opposition, so we would encourage your support. Thank you, Mr. President. Debate is open.
Further debate? Hearing no further debate, Senator Tippett is recognized to close debate.
Mr. President, debate is closed.
Debate being closed, question is House Bill 130 is amended in the Senate. Pass the Senate. Secretary will call the roll.
Bear. Bach.
For me, it was a...
Brackett. Buckner Webb. Cameron. Davis. Durst. Fulcher. Getty. Guthrie. Hagedorn. Hyder. Hill. Johnson. Keogh. Lacey. Lakey. Lodge. Martin. McKenzie. Mortimer. Nonini. Nuxel. Patrick. Pierce. Rice. Schmidt. Sidaway. Stennett. Thane. Tippett. Vick. Work. Winder. Davis. Fulcher. Bach.
Roll call shows 34 ayes, 1 nay, no absent, excused, majority haven't voted in the affirmative. House Bill 130 is amended in the Senate, passed the Senate. The correction of the title, hearing none. Title is approved, and House Bill 130 is amended in the Senate will be returned to the House. And now is for final consideration. House Bill 167 is amended in the Senate. The Secretary will read the bill.
In the House of Representatives, House Bill number 167 as amended in the Senate by Transportation and Defense Committee, an act relating to motor vehicle dealers and salesmen, to remove provisions relating to a non-voting member of the Dealer Advisory Board.
Mr. President?
Sir Hagedorn.
Thank you, Mr. President. I ask unanimous consent that further reading of House Bill 167 as amended in the Senate be dispensed with and a journal show it's been read third time at length, section by section, and placed before the Senate for consideration.
Hearing no objections, Senator Hagedorn is recognized to open debate.
Thank you, Mr. President. Ladies and gentlemen, if you have been around the defense committees for any time at all, you would recognize this is the solution to a problem that we've been trying to solve for many years. Currently, our automobile dealerships, both used car, new car, and ATV motorcycle, are required to have a surety bond. And that surety bond is $20,000 for new and used cars, $10,000 for motorcycles and ATVs. That surety bond costs them quite a bit of money annually to update and to get that surety bond, and quite often doesn't cover the costs if there are any claims against that dealership. So in order to increase that surety bond, which everyone has targeted to be about $50,000, that would almost, more than double the price of the current surety bond, increasing huge barriers to market for new dealerships that might want to get into the business, and also reducing and actually passing through those costs and increasing the cost to buyers that purchase vehicles through those dealerships. The dealerships got together and have created a fund which they call ICAR. The ICAR is the Idaho Consumer Asset Recovery Fund. And is how it works is basically the dealerships, instead of purchasing a surety bond, they spend about the same amount of money and they put it into an account that's been created in the Idaho Treasury. Now, there's a number of surety insurance dealers all over the nation that they buy these bonds from. This would basically be an Idaho self-insuring organization, and it would be run by the board of dealerships. For the same amount of cost, Idaho consumers would be protected up to about $50,000, which is a $250 increase over what the dealers have now. And the consumers are protected through the dealerships up to $120,000 per dealership per year. This account would have a top out of about $2 million. It would open up or remove the barriers of entry for new businesses that wanted to come in. Again, the ICAR board would be created of an advisory board of automobile dealers, the director of the Department of Transportation or his designee. We amended the bill to take off the Attorney General because there might be a conflict of interest there if there's ever any kind of an issue. But the board itself would manage the fees, the annual fees to dealers, and manage the top number of how much money goes into the fund and the claims that are claimed against the fund. This is a great solution to a problem that we've had for a number of years, and is supported by the Idaho dealerships, supported by the Idaho Transportation Board, and hopefully supported by the Idaho legislature. With that, Mr. President, the debate is open.
For the debate,
Mr. President.
Senator Mortimer.
Thank you, Mr. President. Senators, this is an issue that I know many of us have worked on for many years, and I'm glad to see it here. I stand in support of it. I just need to acknowledge that it doesn't go quite far enough. We have an issue in our state that when a dealer does not pass title or something occurs that someone has purchased a car and cannot get clear title from a dealer, they don't have any recourse but going through the courts. And the cost of the courts is so significant that it exceeds normally the cost of the car. So in my opinion, this is a good first step. It's a step of setting up a fund that we can perhaps get to more easily in the future. I recognize right now that it still takes that court to be able to access the fund, but I'm hoping in the future we'll be able to protect those, particularly when the dollar amount of that sale is low enough that they can't get access to this without going through the courts. And I support this legislation. Thank you, Mr. President.
For the debate, Senator Lakey.
Mr. President, thank you. Just for a disclosure, under Rule 39, one of the partners in my firm provides some work for the auto dealers, and I believe provided some input on the language of this bill.
Be so recorded in the journal. Thank you, Senator. Further debate. Hearing no further debate, Senator Hagedorn is recognized. Closed debate.
Thank you, Mr. President. Debate is closed.
Debate being closed. Question is to House Bill 167 is amended in the Senate. Passed the Senate. The Secretary will call the roll.
Bear. Bayer. Bach. Brackett. Buckner-Webb. Cameron. Davis. Durst. Fulcher. Getty. Guthrie. Hagedorn. Hyder. Hill. Johnson.
Senator Johnson.
60 seconds.
60 seconds.
Thank you, Mr. President. Good senators, I like the bill, most everything about it. In Section 49-1608D, it requires new applicants, that is, for initial motor vehicles dealer's license, shall maintain a license bond for 3 consecutive years prior to being eligible to participate in this ICAR fund. And I'm just not comfortable with that, so I'm going to vote against this bill. Thank you.
Senator Johnson will be recorded as voting no.
Keogh. Aye. Lacey. Lakey. Lodge. Martin. McKenzie. Mortimer. Nonini. Nuxel. Patrick. Pierce. Rice. Schmidt. Sidaway. Stennett. Thane. Tippett. Fick. Work. Winder. Davis. Durst. Lodge. Nonini? Nuxel? Pierce? Vic?
Roll call shows 30 ayes, 5 nays, no absent, excused, majority haven't voted in the affirmative. House Bill 167 is amended in the Senate. It's passed the Senate. The correction title, hearing none, the title is approved. House Bill 167 is amended in the Senate, will be returned to the House. Senate now is for final consideration. House Bill 141, Secretary will read the bill.
In the House of Representatives, House Bill Number 141 by Revenue and Taxation Committee, an act relating to exemptions from property taxation.
Mr. President.
Senator Rice.
Mr. President, I ask unanimous consent that further reading of House Bill 141 be dispensed with, and that the journal show that it has been read the third time at length, section by section, and placed before the Senate for final consideration.
Hearing no objection, Senator Rice recognized to open debate.
Mr. President, members of the Senate, this is a bill to fix a misunderstanding that occurred. One of the counties got some erroneous advice to treat gas and oil wells as personal property and to tax them based on the cost to drill them. And first, that ignored a history of what real property is versus personal property that dates clear back to 1066. But in addition, it ignored some principles of property law, and this bill fixes that. Currently, the way we've set up gas and oil wells, every parcel that sits over a pool of gas or oil that's being drawn from shares in the royalties. And as a result, every parcel will increase in value if that pool is being drawn from. And we tax real property by parcels. And so whether the well is on a particular parcel or not makes no difference to the value of that parcel for purposes of real property tax. It's kind of like if you went down to Carl's Jr. and you buy a soda. If you buy a soda, you will pay for the soda. They'll charge you for the soda. They will charge you tax on the purchase of the soda. But when you go and stick a straw in the soda, you don't get an additional tax because it's irrelevant to the cost and value of the soda. It's the same deal with this. The well itself is irrelevant to the actual value of the parcel. And so it is something that it fixes the problem. It clarifies how we tax to a great extent by just removing the temptation to get creative and tax in ways that we don't tax, and in ways that ignore all of the history of our law on real and personal property. I do know that there are some who think that we don't tax enough on oil and gas. This bill doesn't have anything to do with that particular discussion. This is more of a process bill, and with that, debate is open.
To the debate. Senator Lakey.
Mr. President, thank you, and appreciate the comments from the good senator from 10. I also appreciated his soda and straw example. I personally prefer the donut hole example. This would essentially be like taxing the hole in the donut when you pay for the donut. Just wanted to put that example, Senator from 10, on the record, and with that, stand in support of the bill.
For the debate, Senator Stinnett.
Thank you, Mr. President. Would the good senator for 10 yield to a question?
Senator Rice, would you yield?
Mr. President, I would yield.
Senator Stinnett.
Thank you, Mr. President, good senator, and I apologize. We've had so many piecemeal, well, you do tax this, no, we don't tax that, yes, we charge for that, no, we don't drill there, yes, we drill there, and it's been this constant sort of dissecting of what we did in rules and statutes last year, so I'm trying to make sense of this. So I'm trying to understand, you're asking not to have the actual property that the well is sitting on taxed. You're actually talking about a taxing of the structure itself. I'm not quite understanding what the confusion. I'm confused. I guess I'm wondering to understand clearly what the cities and counties are confused about.
Senator Rice.
Mr. President, Senator from 26. The well consists of the hole in the ground, any associated casing that keeps it a hole, and any sealant that would be used to make sure it's not got stuff escaping in funny directions. The problem is that they were looking at treating it as personal property, and a well is not personal property. It's part of the real estate. The second thing is that if you were to treat it as a separate item of real property, you wouldn't be catching the actual value because you already get that in the value of the parcel. So what this does is says this is not some separate item that has inherent value, and there's a number of things that display that, such as dry wells don't change the value of the parcel, aren't going to increase it. Wells that aren't commercially viable aren't going to increase it, but commercially viable wells will increase the value of the parcel, but the well itself is irrelevant to that because, for instance, if you got 10 parcels that are sitting over the same pool of oil or gas, which one you stick the straw in doesn't make any difference. They all will have income from the oil or gas that's being removed, and thus the value of those parcels will increase, but you catch that in the value of the parcels.
If the good senator yield to one more question.
Senator Rice, would you yield?
I would yield.
Thank
Senator
you.
Stand up for the inquiry.
Thank you, Mr. President. So just so I'm clear, as it sits right now, which is not changing, the actual parcel itself that the well sits on is still eligible to collect taxes from as a property tax, as would be usual on any land. Is that correct?
Senator Rice?
Mr. President, Senator from 26, that is correct.
Thank you. Thank you, Mr. President.
For the debate, Senator Pierce.
Mr. President, under Rule 39H, I would like to disclose that I have some oil and gas leases on some of my property, and if the seismic ever turns out, and if the price of natural gas goes up, and if the company decides to drill, I may have a well there someday. Thank you.
Be so recorded. Senator Work.
Mr. President, members of the Senate, I did pass out a little sheet today. I don't have a particular problem with the bill. I think that not taxing the straw is probably a good thing. I do have a little issue with the fact that we're starting to piecemeal our tax policy when it comes to oil and gas. And I passed out the piece of paper just so everybody's aware that there are states that have comprehensive policies about how we tax a resource. It's a one-time resource. Remember, once this resource gets removed, it's gone. And when we have booms that occur in counties, you can have a lot of pressure on local governments, and those revenues need to be there for local governments in order for those local governments to respond appropriately to issues that are happening in their local areas. And of course, the people of the state should be deriving substantial benefit in terms of services, education, whatever it is. So I just passed this out in terms of this debate to just remind us that we should be looking at a comprehensive policy when it comes to oil and gas and how we might derive the best benefit for the people of the state of Idaho. But I will be supporting this legislation. Thank you, Mr. President.
For the debate, Senator Bach.
Yes, Mr. President, with the senator from District 10.
Senator Rice, would you
yield to question?
Mr. President, I would yield.
Thank you, Mr. President, and good senator. Currently, I'm trying to piece together all the different elements of property interest here. Based upon your statement that the well is part of the real property, I would assume that this would affect the value of the real property and therefore increase the assessment for real estate purposes. Is that your understanding?
Senator Rice?
Mr. President, Senator from 16. The removal of natural gas, the payment or oil, the payment of the royalties would increase the value of the parcel. It wouldn't, just like it would any parcel that sits over the pool. So the well itself isn't where that value is measured, and so it just clarifies. Look to the things that are measured.
Senator Bach?
Yes, would the senator yield further?
Senator Rice?
I would yield.
Senator Bach?
Okay, thank you, Mr. President. Good senator, now you've really confused me. Again, my hypothesis is that once you have a well drilled on property, if I want to sell that property, it's going to be worth more. What I'm separate and aside from the extraction of the resource, I'm just talking about the real property. Would it be your understanding, if you know, that once drilled, the well increases the value of property, and there would be a corresponding increase in the assessed value from which the authorities could derive property tax, real property tax?
Senator Rice.
Mr. President, Senator from 16. The well itself would not be what drives that increase in value, because it could be on a different parcel, but the parcel, if there is oil and gas extracted from a pool under the parcel would sell for more. That value would be taxed even with this bill.
Would the senator yield further?
Senator Rice.
I would.
Mr. President and good senator, now, is there a tax on the extraction of the resource once the well becomes operational?
Senator Rice.
Mr. President, Senator from 16, there is a severance tax.
Senator Bach.
Would the senator yield further?
Senator Rice.
I would.
Okay, and that severance tax is paid to whom?
Senator Rice.
Mr. President, a senator from 16, there's a 2.5% severance tax that is paid. It gets divided up. There's a percentage that will go to the state. There will be a percentage that goes to the schools within the state. There will be a percentage that goes to the county where the well is located. There's a percentage that gets divided up amongst the cities within the county where the well is located. There is also a portion of that severance tax that goes into a fund that's held for later if the economic effects when at the time that the wells are no longer in operation in that county.
Senator Bach.
Yeah, thank you, good senator. Mr. President, debate the bill.
You have the floor.
Mr. President, good senators, I just wanted to I guess, echo what the senator from District 17 said, and that this seems like a sensible bill, and I'm going to support it. I may disagree with the assessment strategies of the good senator from District 10, but that's for another day. But I will be supporting this bill.
Further debate? Hearing no further debate, Senator Rice recognized closed debate.
Mr. President, debate is closed.
Debate being closed, question is, shall House Bill 141 pass Senate? Senator Winder.
President.
Secretary will call the roll.
Baer. Bayer. Bach. Brackett. Buckner Webb. Cameron. Davis. Durst. Fulcher. Getty. Guthrie. Hagedorn. Hyder. Hill. Johnson. Keogh. Lacey. Lakey. Lodge. Martin. McKenzie. Mortimer. Nonini. Nuxel. Patrick. Pierce. Rice. Schmidt. Sidaway. Stennett. Thane. Tippett. Vick. Work. Winder. Buckner Webb. Davis. Fulcher.
call shows 34 ayes, 1 nay, no absence, excused, majority having voted in the affirmative. House Bill 141 is passed Senate. The correction title, hearing none, title is approved, and House Bill 141 will be returned to the House. And now, for final consideration, House Bill 233. The Secretary will read the bill.
In the House of Representatives, House Bill number 233 by Appropriations Committee.
Mr. President.
Senator Smith.
Mr. President, I ask unanimous consent that further reading of House Bill 233 be dispensed with. The journal show it has been read at length, section by section, a third time, and placed before us for final consideration.
Hearing no objection, Senator Smith is recognized to open debate.
Thank you, Mr. President. House Bill 233 is the appropriation bill for the Idaho Commission on the Arts. This fiscal year, appropriation to the Idaho Commission on the Arts in the amount of $1,811,500, with full-time equivalent positions capped at 10. The Commission on the Arts seeks to stimulate and encourage the study and presentation of the arts and public interest and participation therein, and to encourage and assist freedom of artistic expression. Areas of emphasis include music, theater, dance, creative writing, painting, sculpture, architecture, folk and traditional arts, and crafts. The Commission engages in many activities, including providing grants to arts organizations to support the public programs in the arts, fellowship in the recognition of artistic excellence by individual artists, apprenticeships, writer-in-residence literature programs. The governor appoints a 13-member Commission on the Arts, which in turn hires an executive director. The funding for the Commission of the Arts is comprised of a mix of federal, general, and dedicated funds. This year's appropriation represents a 0.5% increase in general fund, a 3.5% increase in dedicated funding, and a 1.4% increase in federal funds, for a total of a 1.2% increase in funding for the Commission on the Arts. And Mr. President, if I may, fellow senators, I ask your support for these things arty. Please make your aye vote loud and hearty. The arts inspire and strengthen Idaho. But if you can't support art, then just vote no. Thank you, Mr. President. Debate is open.
Thank you, Senator. Is there further debate?
Mr. President,
Senator Nuxall.
I appreciate Senator from 5 and his comments. I just want to say that art is very important. Art defines culture, and culture defines art. That's for sure. I actually minored in art at Gonzaga. I've done a lot of drawing. My family is very musically inclined. They're into music and art, but I just believe that this should not be a government obligation and should be used where the money could be used for a lot other more vital projects. So I'm going to vote no on this. Thank you.
Is there further debate? Hearing none, Senator Schmidt is recognized to close debate.
Thank you, Mr. President. That lively debate should help inspire folks to make a weighty decision. So I would support your aye vote. Debate is closed.
Debate being closed, the question is, shall House Bill 233 pass the Senate? The Secretary will call the roll.
Bear. Bayer. Bogg. Brackett. Buckner-Webb. Cameron. Davis. Durst. Fulcher. Getty. Guthrie. Hagedorn. Hyder. Hill.
Aye.
Johnson.
President.
Senator Johnson, for what
Thank you,
purpose do you
Mr.
stand?
President. Thank you. 60 seconds, Mr. President.
Senator has 60 seconds to explain his vote.
Thank you, Mr. President. Good senators, if you've ever seen a good painting of Seurat or one of the other Impressionists, I don't know how you can't be moved by art. So this senator's going to vote yes. Thank you.
Senator Johnson votes aye.
Keogh. Lacey. Lakey, Lodge, Martin, McKenzie, Mortimer, Nonini, Nuxel, Patrick, Pierce, Rice, Schmidt, Sidaway, Stennett, Thane, Tippett, Vick, Work, Winder, Davis, Getty, Hagedorn, Hyder, Lakey, Nonini, Rice,
Roll call shows 25 aye, 10 nay. A majority having voted in the affirmative, House Bill 233 has passed the Senate. Is there correction to the title? Hearing none, title is approved, and House Bill 233 will be returned to the House of Representatives. Senate now has before it for final consideration House Bill 234. Secretary will read the bill.
In the House of Representatives, House Bill Number 234 by Appropriations Committee, an act appropriating monies to the Division of Human Resources for fiscal year.
Senator Thane.
Mr. President, I ask unanimous consent that we dispense with further reading of House Bill 234, and the journal show that it's been read at length the third time and placed before the Senate for final consideration.
Hearing no objection, is so ordered. Senator Thane from District 8 is recognized to open debate.
Thank you. This bill is the fiscal year 2014 appropriation to the Division of Human Resources in the amount of $1,678,100 in dedicated funds and a full-time position cap of 12. The division manages a comprehensive personal merit system for classified state employees. The system consists of recruitment, applicant screening, examination systems, job classification, salary administration, employee training and development, an appeals process for disciplinary actions, and an employee information system. Most of the former powers and duties of the Personnel Commission were statutorily transferred to the Administrator of the Division of Human Resources in fiscal year 2000. The Personnel Commission still exists to hear appeals of dismissals, demotions, or suspensions by agency directors, or rulings made by the Administrator. The Division Administrator is appointed by and reports to the Governor. This budget is funded entirely with fees collected from a portion of each classified employee's position's salary. The appropriation reflects the recommendation of the gentleman on the second floor with two minor exceptions. This budget removes $200 for the increase in risk management fees, and it also removes one FTP because the position is currently vacant and there's no funding available to fill the position in fiscal year 2014. This bill is a total change of 0.1% over fiscal year 2013. This appropriation is simply a maintenance of current operations budget and is funded entirely with dedicated funds, and I urge your support.
Debate being open, is there further debate? Hearing none, Senator Thane is recognized to close debate.
Thank you. Debate is closed.
Debate being closed, the question is, shall House Bill 234 pass the Senate? Secretary will call the roll.
Bear, Bayer, Bach, Brackett, Buckner-Webb, Cameron, Davis, Durst.
Mr. President.
Senator Durst, for what purpose do you stand?
Mr. President, to explain my vote.
Senator has 60 seconds.
Thank you, Mr. President. Just as by way of an explanation, I'm voting no on many of these appropriations bills this year because I feel like two things are lacking. First is an increase for employee pay. I think that it's fundamentally wrong that we've neglected our state employees and these budgets don't reflect the value in them that I believe that they have. Secondarily, with this specific appropriation, I feel that the Division of Human Resources has lacked the leadership it needs to have to fight for those increases. I believe that the administrator from the Division of Human Resources should be an advocate for state employees and should fight for employment for raises for those employees. That hasn't happened. I'll be voting no.
Senator Durst votes no.
Fulcher, Getty, Guthrie, Hagedorn, Hyder, Hill, Johnson.
Mr. President,
Senator Johnson.
60 seconds, Mr. President.
Senator has 60 seconds to explain his vote.
Thank you, Mr. President. Good senators, just as a reminder, the Joint Finance and Appropriations Committee did include intent language on all appropriation bills this year that any salary savings be directed towards employee compensation and to reward those employees. So we are very concerned, and we did take note of that. Thank you, Mr. President. I'm voting aye.
Senator Johnson votes aye.
Keogh, Lacey, Lakey, Lodge, Martin, McKenzie, Mortimer, Nonini, Nuxel, Patrick, Pierce, Rice, Schmidt, Sidaway, Stennett, Thane, Tippett, Vic.
Senator Tippett, for what reason?
Excuse me, Mr. President, 60 seconds, please.
Senator has 1 minute to explain his vote.
Thank you, Mr. President. Senators, I just wanted to comment on the previous comments that were made about the Division of Human Resources being an advocate for state employees. I see their role as being a little different. I think they have the responsibility to keep us informed of the current situation and whether or not state employees are being paid at a competitive rate, and I think they've done a very good job of doing that. I think the policy decision about whether or not state employees should be given a pay increase is up to us, and we certainly have to consider the financial impact and the resources that we have available. I think they're doing a great job. The senator votes aye.
Senator Tippett votes aye.
Vic, Work, Winder, Davis,
Roll call shows 34 aye, 1 nay. A majority having voted in the affirmative, Senate Bill 234 has passed the Senate. Is there correction to the title? Hearing none, title is approved, and Senate Bill 234 will be returned to the House of Representatives. Senate now has before it for final consideration House Bill 235. Secretary will read the bill.
In the House of Representatives, House Bill Number 235 by Appropriations Committee, an act appropriating monies to the Public Employee Retirement System for fiscal year 2014.
Mr. President.
Senator Johnson.
Thank you, Mr. President. I ask unanimous consent that further reading of House Bill 235 be dispensed with, and the journal show that it has been read the third time at length, section by section, and placed before the Senate for final consideration.
Hearing no objection, it is so ordered. Senator Johnson from District 6 is recognized to open debate on the bill.
Thank you, Mr. President. Good senators, this is the fiscal year 2014 appropriation bill to the Public Employee Retirement System of Idaho in the amount of $6,860,000 with full-time equivalent positions capped at 63. The Retirement Administration Program administers the PERSI base plan, which is a defined benefit retirement plan that is mandatory for all eligible state and school district employees and for employees of political subdivisions which have elected to participate. It provides separation, disability, death, and survivor benefits. The PERSI Choice Plan is a defined contribution retirement plan which provides a 401k plan option to approximately 65 eligible active PERSI members. The Choice Plan is in addition to and separate from the defined benefit plan. The Portfolio Investment Program is responsible for the management of PERSI assets to ensure secure long-term returns on investments while minimizing investment costs. Administrative costs of the portfolio investment come under a fixed appropriation, and the remaining investment costs continue to operate under a perpetual appropriation as provided in Section 59-1311 Idaho Code. This budget is comprised of dedicated funds only. This appropriation is a maintenance of current operations budget only. Current value of PERSI's portfolio is approximately $2.6 billion, and it's doing well, I understand. Mr. President, with that, debate is open.
Debate being open, is there further debate? Hearing none, Senator Johnson is recognized to close debate on the bill.
Thank you, Mr. President. Debate is closed.
Debate being closed, the question is, shall House Bill 235 pass the Senate? Senator Winder?
Thank you, Mr. President. I ask unanimous consent the roll call vote used for the passage of Senate Bill 1079 be now used for the passage of House Bill 235.
You've heard the unanimous consent request. Is there objection? Hearing none, it is so ordered. Roll call shows 35 aye. Majority having voted in the affirmative, House Bill 235 has passed the Senate. Is there correction to the title? Hearing none, title is approved, and House Bill 235 will be returned to the House of Representatives. Senate now has before final consideration House Bill 236. Secretary will read the bill.
In the House of Representatives, House Bill number 236 by Appropriations Committee, an act appropriating monies to the Idaho State Lottery for fiscal year
Mr. President.
Senator Vick.
Mr. President, I ask unanimous consent that further reading of House Bill 236 be dispensed with, and the journal show it has been read the third time at length, section by section, and placed before the Senate for final consideration.
Hearing no objection, is so ordered. Senator Vick is recognized to open debate.
Thank you, Mr. President. Good senators, this is the budget for the state lottery. House Bill 236 is the fiscal year 2014 appropriation in the amount of $5,423,700, with full-time equivalent positions capped at 47. Since its inception in 1989, the lottery has distributed more than $510.8 million in dividends to the Permanent Building Fund and School District Building Fund. The dividend from the revenues are split equally between the Permanent Building Fund and the School District Building Fund until revenues reach $35 million in 1 year. Once revenues reach $35 million, the additional amounts are split three ways, with the bond levy equalization receiving 25% of the excess, and the Permanent Building Fund and School District Building Fund splitting 75% of the excess equally. After fiscal year 2015, the lottery will again provide half of the net income to the Permanent Building Fund and half of the net income to the School District Building Fund. This year's budget includes increases for benefit cost adjustments, contract inflation, replacement items, and a reduction in statewide cost allocation. This budget also includes some standard intent language for the state lottery that provide the ability to pay for variable budgetary items with continuous appropriation authority: the retail commissions, advertising, prizes, and gaming provider fees. There are still fiscal constraints on the amount of money the state lottery can spend on administrative costs, which is set statutorily at 15% of all revenues. With that, debate is open.
Debate being open, is there further debate? Hearing none, Senator Vick is recognized to close debate.
Thank you, Mr. President. In closing, I would just say, even though I have not personally contributed to any of the funds in the state lottery account, many of them are spent for good purposes. Thank you. Debate is closed.
Debate being closed, the question is, shall House Bill 236 pass the Senate? Senator Winder?
Thank you, Mr. President. I ask unanimous consent the roll call vote used for the passage of Senate Bill 1079 be now used for the passage of House Bill 236.
You've heard the unanimous consent request. Is there objection? Hearing none, it is so ordered. Roll call shows 35 aye, a majority having voted in the affirmative. House Bill 236 has passed the Senate. Is there correction to the title? Hearing none, title is approved, and House Bill 236 will be returned to the House of Representatives.
Senate now has for final consideration House Bill 237. Secretary will read the bill.
House Bill number 237 by Appropriations Committee, an act appropriating monies to the Division of Building Safety for fiscal year 2014, limiting the number of authorized full-time equivalent positions and providing guidance for employee compensation.
Mr. President.
Senator Mortimer.
Mr. President, I ask unanimous consent that further reading of House Bill 237 be dispensed with, and the journal show that it has been read the third time at length, section by section, and placed before the Senate for final consideration.
Hearing no objection, Senator Mortimer is recognized to open debate.
Thank you, Mr. President. Senators, House Bill 237 is the fiscal year 2014 appropriation to the Division of Building Safety in the amount of $10,949,000, with full-time equivalent positions capped at 121. The Division of Building Safety administers 5 bureaus and houses 7 boards. Funding for the building, electrical, plumbing, public works, contractor licensing, and heating, ventilation, and air conditioning bureaus is provided through fees for licenses, permits, plan reviews, and apprentice training registrations. Other programs operated by the division include the Industrial and Logging Safety Programs, funded by transfers from the Industrial Commission, and an Energy Code program funded through grant monies from the U.S. Department of Energy and the Northwest Energy Efficiency Alliance. This year's budget includes increases for benefit cost adjustments, contract inflation, replacement items, and a reduction for statewide cost allocation. This appropriation also reduces the number of full-time equivalent positions by 10 and reduces the personnel costs appropriation by $500,000. This reduction is to help align actual spending with the budget. This budget is a 2.5 overall decrease below the fiscal year 2013. These are all dedicated funds. Mr. President, debate is open.
For the debate. Hearing no further debate, Senator Mortimer is recognized. Close debate.
Thank you, Mr. President. Debate is closed.
Debate being closed. Question is House Bill 237 passed the Senate. Senator Winder.
Thank you, Mr. President. I ask unanimous consent the roll call vote used for the passage of Senate Bill 1079 be now used for the passage of House Bill 237.
Hearing no objection, roll call shows 35 ayes, no nays, no abstentions, excused, majority haven't voted in the affirmative. House Bill 237 is passed the Senate. The correction title. Hearing none, title is approved. House Bill 237 will be returned to the House and now is for final consideration. House Bill 238, Secretary will read the bill.
House of Representatives, House Bill number 238 by Appropriations Committee, an act appropriating monies to the Department of Finance for fiscal year 2014.
Mr. President.
Senator Cameron.
Mr. President, I ask unanimous consent to further reading of House Bill 238 be dispensed with and the journal show it's been read at length, section by section, and is now properly before the Senate for final consideration.
Hearing no objection, Senator Cameron is recognized to open debate.
Thank you, Mr. President and Senators. House Bill 238 is the fiscal year 2014 appropriation for the Department of Finance. It's in the amount of $6,812,800 with full-time equivalent positions capped at 64. As you know, the Department of Finance is charged with regulating state-chartered banks, financial institutions, regulatory lenders, securities issuers, brokers, broker-dealers, stockbrokers, residential mortgage brokers, lenders, investment advisors, and sales personnel, collection agencies, and many others. This agency is strictly funded entirely from fees levied by those who are being regulated. The amount of the fees collected in excess of their appropriation is then transferred to the general fund. Mr. President, I think it goes also I want to reiterate on the comments that the good Senator from 6 made earlier. All of these budgets have language in them, as does this one, that any salary savings can be applied towards personnel. This one goes a step further. This one has an additional $196,600 for 19 very difficult, hard-to-fill positions for which we continually lose to the federal government and to others. And so in this case, the committee saw fit to use some of their existing resources, some of the money that they raised through fees, in order to help keep those well-qualified and important employees. With that, Mr. President, debate is open.
For the debate, Senator Tippett.
Mr. President, I wonder if the sponsor would yield to a question.
Senator Cameron. Senator Tippett.
Thank you, Mr. President and Senator. I realize these are all dedicated funds, but I think we have to be careful that we don't grow the number of employees that we have too quickly, and that makes it certainly more difficult to provide salary and benefits to the employees that we have when we grow too quickly. And I see that we've got a couple of additional positions here. Could you give us some quick justification for adding 2 employees to this department, please?
Thank you, Mr. Chairman, and thank you, good Senator from 32. First of all, the one is an office specialist, too, and the second position is an examiner for money transmitters. And it's simply, in my recollection is, and certainly the good senator from 35, I think, or 30, wherever he is, 30, can answer maybe even a little further, but they were positions that the department felt were needed in order to maintain their regulatory ability, and the committee went along with that.
Further debate? Hearing no further debate, Senator Cameron is recognized to close debate.
Mr. President, could the Senate go at ease?
Without objection, Senate be at ease.
Mr. President, while we're at ease, if I might make an introduction, I'd like to introduce, we have some students with us here, senators, from the Idaho Arts Charter, which is in my district, District 12. My friend, Mr. Christian Hughes, is here, and Mr. Hughes teaches the American government class. Mr. Hughes is also a reasonably good fly fisherman, I understand, at least from photos that I've seen. Also, we have Miss Angie Horn and her careers class. If Miss Horn is here. Okay, all right. But senators, if you please join me in welcoming them to the Senate today.
Welcome to Idaho in Session, Legislature Live. Idaho in Session is sponsored by the Idaho State Broadcasters Association, the J.A. and Catherine Albertson Foundation, Union Pacific Foundation, Idaho Association of Counties, Idaho Cable Telecommunications Association, Association of Idaho Cities, and your contributions to the Idaho Public Television Endowment.
Senate will come to order. Senate's 13th order of business and was about to commence closing debate on House Bill 238. Senator Cameron.
Thank you, Mr. President, and I apologize for taking a break for just a second. I needed to confer with my good friend from 30. And with that, debate is closed.
Mr. President.
Senator Mortimer.
Mr. President, thank you for giving us that time to talk a little bit about that. But I also have a disclosure. My son works for the Department of Finance. He has worked there approximately a year and a half. Thank you.
It will be so recorded in the Journal. Debate being closed. Questions to House Bill 238 passed Senate. Senator Winder.
Thank you, Mr. President. To ask unanimous consent, the roll call vote used for the passage of Senate Bill 1079 be now used for the passage of House Bill 238.
Hearing no objection, roll call shows 35 ayes, no nays, no abstentions, excused, majority haven't voted affirmative. House Bill 238 is passed. Senate, the correction title. Hearing none, title is approved. House Bill 238 will be returned to the House. Senate now is for final consideration. House Bill 184. Secretary will read the bill.
In the House of Representatives, House Bill Number 184 by Revenue and Taxation Committee, an act relating to income tax, to revise a time period relating to a net
Mr.
operating...
President.
Senator Rice.
Mr. President, I ask unanimous consent that further reading of House Bill 184 be dispensed with, that the Journal show has been read in full, section by section, the third time, and placed before the Senate for final consideration.
Hearing no objection, Senator Rice recognized open debate.
Mr. President, members of the Senate, this is a rather wordy bill for just a jot, but it deals with net operating losses in our tax code. And the way things have been working, a person's allowed to take a net operating loss, and they can either offset income in the year in which it occurred, or they can take it into the previous 2 years by amending those tax returns, or you can carry it forward for future tax returns. Part of the problem is that if he didn't mark a box on the tax return, he could only take it back to the prior 2 years, which on occasion doesn't use up the whole net operating loss. And so what this bill does is makes it so that you don't have to mark that box, and you can still take it back, and if there's any left, you can take it forward into future years. So it kind of eliminates a problem that reminds me of biblical times with jots and tittles. But with that, debate is open.
Further debate. Senator Bach.
Thank you, Mr. President. Would the good senator from District 10 respond to
Senator
the
Rice,
question?
would you respond?
Mr. President, I would yield.
Senator Bach.
Yeah, thank you, Mr. President. Thank you, good senator. I'm curious to know if we have a 2-year loss carry back, and now there's going to be no box checked for carrying it back for 2 years. Is that then become the automatic position on your return? Or another way of asking the same question, how does one carry it back only for 1 year?
Senator Rice.
Mr. President, Senator from 16, you'll still be able to carry it back by filing an amended return, but what you don't use up, you'll be able to carry forward to future years as well. So it gives you a time period for carrybacks, and then it lets you, but it's only 2 years, but you have to do the amendment within a specific period of time.
Mr. President, will the good senator respond to yet another?
Senator Rice.
Mr. President, I would.
Senator Bach.
Thank you, Mr. President, good senator. So I want to make sure I understand, my understanding is correct. If you only file an amended return, let's say for 2011, the State Tax Commission will assume you're only doing a carryback for 1 year, end of story, and if there's any left over, you carry forward. Is that correct?
Senator Rice.
Mr. President, that would be correct, and you would have 1 year from the end of the taxable year of the net operating loss to file the amended return for prior tax years.
Okay, thank you. Thank you.
Senator Hill.
Mr. President, debate bill, I just want to explain I'm fully in favor of this bill. All this is doing is changing the way the election is made. Right now, you have to check a box when you file the return where the loss was created to say whether or not you're carrying it back, whether you check it or don't check it. The way the Internal Revenue Service does it and the way we're changing this to is instead of checking a box, you will make the election by filing the amended return. It gives you a year to file that amended return instead of having to make that decision when you file the original return. And it doesn't change any of the years that are available for carry back or carry forward. It's just a matter of making the election. Thank you, Mr. President.
Further debate? Hearing no further debate, Senator Rice recognizes closed debate.
Mr. President, debate is closed.
Debate being closed. The question is, House Bill 184 passed the Senate. Secretary will call the roll. Or Senator Winder? Call the roll.
Bear. Bach. Brackett. Buckner-Webb. Cameron. Davis. Durst. Fulcher. Getty. Guthrie. Hagedorn. Hyder. Hill. Johnson. Keogh. Lacey. Lakey. Lodge. Martin. McKenzie. Mortimer. Nonini. Nuxel. Patrick. Pierce. Rice. Schmidt. Sidaway. Stennett. Thane. Tippett. Vick. Burke. Winder. Durst.
Roll call shows 35 aye. Majority having voted in the affirmative, House Bill 184 has passed the Senate. Is there a correction to the title? Hearing none, title is approved, and House Bill 184 will be returned to the House of Representatives. Senate now has before it for final consideration House Bill 187. Secretary will read the bill.
In the House of Representatives, House Bill number 187 by Revenue and Taxation Committee, an act relating to use tax to clarify serving sizes for free tastings of wine and beer, to provide that the use...
Mr. President.
Senator Bayer.
Mr. President, I ask unanimous consent that further reading of House Bill 187 be dispensed with and that the journal show it's been read for the third time at length, section by section, and placed before the Senate for final consideration.
Hearing no objection is so ordered, and Senator Bayer is recognized to open debate on the bill.
Thank you, Mr. President. Thank you, good senators. Last year, industry presented legislation to exempt tastings of beverages, which also included wine and beer, from the payment of use taxes. The legislation was in response to a tax commission letter sent to the industry in 2011, which mandated Idaho business owners to go back 3 years into their records and pay use taxes of 6% on all free samples that were given to potential customers. The legislation passed, and the Senate and House was signed into law in 2012. During presentations of last year's legislation, a question was raised multiple times asking why the legislation did not also include free food tastings. The response was that industry tried to add the free food tastings to the legislation at that time, but the Tax Commission had some concerns and wanted to be able to review that. The legislation you see before you today in House Bill 187 is legislation that both industry and the Tax Commission agree upon after drafting together to address these food tasting issues. House Bill 187 amends Section 63-3621 Idaho Code to do the following. First, it quantifies the tasting of wine and beer as a maximum serving allowed by federal or state law. This was inadvertently left out of last year's legislative language. And there are examples currently in Idaho statute that allow a maximum of 1.5 ounces for a wine tasting, and federal law which references 8 ounces for a beer tasting as to be served as a tasting. Second, and the most important thing this legislation does is it exempts tastings of food from the payment of use taxes. So if you're a vendor at a farmer's market and you have tastings of slices of apples or specialty popcorn or things like that that you are giving out free, you'll be exempt from paying the use taxes on those tastings. The last thing this legislation does is define tastings of non-alcoholic beverages or food as a sample from a unit available for sale at that tasting location. The industry asked the Tax Commission if it could help with the fiscal impact and quantify that, but they were told it could not, and so therefore the fiscal impact is listed as de minimis. This is the same fiscal impact that we had last year in the beverage bill. Ladies and gentlemen, good senators, this is a good tax policy for Idaho business owners and is supported by the Idaho Heartland Coalition, Food Producers of Idaho, and the Idaho Retailers Association, and I would ask for your support of House Bill 187. With that, Mr. President, debate is open.
Debate being open, is there further debate? Hearing none, Senator Bayer is recognized to close debate.
Thank you, Mr. President. Debate is closed.
Debate being closed, the question is, shall House Bill 187 pass the Senate? Senator Winder?
I'd ask unanimous consent the roll call vote used for the passage of Senate Bill 1079 be now used for the passage of House Bill 187.
For the unanimous consent request, is there objection? Hearing none, it is so ordered. Roll call shows 35 aye, majority having voted in the affirmative. House Bill 187 has passed the Senate. Is there correction to the title? Hearing none, title is approved, and House Bill 187 will be returned to the House of Representatives.
Mr. President.
Senator Davis.
Mr. President, I ask unanimous consent the Senate return to the fourth order of business.
Hearing no objection, the Senate will return to the fourth order of business, reading of communications.
Mr. President, I ask unanimous consent the Senate advance to the fifth order of business.
Hearing no objection, the Senate will advance to the fifth order of business, petitions, resolutions, and memorials.
Mr. President, personal privilege.
Senator has the floor.
Mr. President, Senators, we will soon recess till the hour of 4 p.m. today. And when we return, it is our intent to go back to the 13th order as quickly as we can. Any administrative work between the 5th and the 13th we'll try to pick up. But we intend to go back and start with House Bill 26 and work our way forward. It is our intent to adjourn today at 5:30 p.m. for planning purposes. Prior to recess, I ask if there are introductions or announcements.
Mr. President.
Senator McKenzie.
I just realized my wife's in the gallery. She's over here quite a bit, but this session, though, I haven't been able to introduce her yet. So please help welcome Renee.
Senator Davis.
Mr. President, Senator McKenzie, that was a good move because I was about to introduce your wife to the Senate. I do want to at least recognize before we go at recess that today is also another birthday. It is Capital Marion's birthday today. When she first applied for the position and we interviewed, I really liked her. I thought she is going to be a great addition, and all of that has turned out to be true. Her name is Marion Smith. My wife's name is Marion Davis. When I went home and told my wife I had hired a new person, she asked what her name was. I said, well, her name is Marion Smith. Well, my wife was not happy that there was another Marion involved in any aspect of my life. And so from that point forward, I have referred to her as Capital Marion. That is spelled T-O-L, not T-A-L, because the T-A-L Capital Marion in my life is my wife. And so if you will, throughout the day, stop by and wish her a wonderful birthday. I'd tell you how old she is, but that would be inappropriate. She is, however, now my age. And I could tell you what that was, but not here in this moment. Mr. President, I move that the Senate recess till the hour of 4 p.m. today.
Mr. President, I second the motion.
You've heard the motion and the second that the Senate recess until 4 p.m. this afternoon. All in favor say aye. Opposed, nay. Ayes have it. Senate will stand in recess.